topic which I'm going to speak on is legal research. I want to share my screen. I tried to split my presentation into 5 thematic segments. One is what is legal research, wherein I will be talking about what legal research means, what are the essentials. The second theme is who can be a good researcher. Third one is legal research perspectives, its essence. And fourth one is why to undertake legal research. And fifth one is how to do legal research. These are the 5 major themes which I will be speaking on. So now let me start with what is the legal research. Now, legal research basically is an inquiry into a legal fact. Inquiry into a legal fact. Now, when I say inquiry into a legal fact, this inquiry has to be a systematic and scientific one. So, if research, to speak in general terms, involves intelligent, diligent search for facts and connecting these facts to the fact which are put to inquiry. So therefore, researcher tries to focus attention on specific problem which has put to inquiry and look at it objectively in the light of the facts which he or she has collected. So therefore, when researcher tries to collate the facts, interpret those facts about the legal fact or any fact, now he has to use special tools for collecting that information. Why? Because research is always evidence-based. Research is evidence-based. Therefore, you need to collect the information, the facts about the legal fact which you put to inquire. So, put in general terms, I'm trying to make it short. To put it general terms, that research is systematic scientific inquiry of a legal fact, and this legal fact must be of interest to the researcher and of his interest. So I will try to put in a formula that legal research is equal to LR is equal to SSRLF. LR stands for legal research, S stands for systematic, second stands for scientific, I stands for inquiry, LR stands for legal fact. Therefore, legal research is nothing but systematic scientific inquiry of a legal fact of the interest of the researcher, with a quest to add to the existing knowledge or take that field ahead. Take that field ahead. That is what legal research is. Now let me impress upon you on the potential legal researchers that you need to put a legal fact to inquiry with evidence, facts, and so that you can take that field a step ahead. What is required for you is that you must add something to existing knowledge. That is what the sine qua non of legal research. Now, therefore, the question is, if suppose you undertake a legal research, now what is that which you need to do? Now, there are 2 special characteristics for a legal researcher to keep in mind. The first one is that he needs to first ascertain law on the given legal fact. Now, before I go to these 2 requirements, let me try to explain the term legal fact in the sense in which I'm using it. Now, legal fact can be a provision of law, a doctrine, a concept, a statute, an institution. So, whatever may be the legal fact that you put to inquiry, that is a legal fact. Legal fact can be, as I said earlier, a provision, for example, Article 21 of the Indian Constitution. It may part of it, personal liberty or life, whole enactment like constitutional law or environmental law, maybe an institution like Supreme Court or any other legal institution. So legal fact, I'm using it in broader sense. So therefore, legal research is systematic scientific inquiry into a legal fact. And when I say systematic scientific, you need to understand 2 things which are must for a legal researcher. The first one is that first researcher has to ascertain law on a given topic, ascertain law on a given legal fact. Now, why this is required? This is a unique feature of legal research, that legal researcher cannot proceed further without ascertaining law on the legal fact. But let me tell you that this task is not that easy. Why it is not easy? Because law on a given topic may be scattered. It is not necessarily that law may be in one statute or in one enactment. Law on the topic may be scattered in different legislations, You need to first collate, understand, appreciate that legal framework on the topic which you are put to inquiry. Again, this is not enough. This primary legislation is always supplemented by secondary legislation in the form of rules, regulations, orders, notifications, bylaws. Therefore, you need to lay your hands on the second legislation to give a kind of comprehensive framework of that legal fact. Again, this is not enough. We being a common law country, what you need to look into is judicial pronouncements, because particular Supreme Court is authorized to declare law, and that law is binding on all courts in the territory of India. Therefore, you need to look into judicial pronouncements, particularly of the Supreme Court and the High Courts, to understand the kind of interpretation which these courts have given to the law which you have collected for the legal fact which you have to put in value. So therefore, this is what you need to do first. Therefore, and this is again not enough. The fourth thing which you need to do, it is merely reading of law, case law, second legislation is not enough. You must be in a position to understand, analyze underlying legal propositions. And those legal propositions, along with the standard provisions and the legislation and the case law, probably you may get a certain the law on the good. This is one requirement which you need to do. The second thing which you need to keep in mind as a particular feature of legal research is that you need to ensure that your inquiry at the end of the day adds something to the existing knowledge. It is advancement of science of law. Therefore, researcher has to always be alert that his research at the end of the day is going to contribute something to the existing knowledge. Now, therefore, essentials of legal research, if you allow me to say, I will say there are two essentials. One is scientific inquiry and one systematic approach. Now, when a scientific inquiry, what does it mean? Scientific inquiry has the following attributes. One is that you must have a logical reasoning. When you look at a legal fact, you must have a logical reasoning. Logical reasoning from the formulation of research problem to your conclusions. Now, the way in which you identify a legal fact for inquiry, collation of the facts, analysis of those facts, drawing inferences from those facts, you must be logical. Therefore, you need to be logical from the first step of research, that is formulation of research problem to the conclusion, and this has to be done in a systematic, theoretical way. The first attribute of scientific method. Second attribute is that you need to be objective. So therefore, you have to be very, very objective when you look at the legal fact. The facts which you have collected, the inferences which you have drawn, you need to be very objective. That is what the requirement of scientific method. So the third attribute of scientific method is that whatever inferences you draw, at the end of the day, there must be a propositional inferences, propositions. And these propositions which you connect, that one probably that may lead to a theory. And fourth is that you must be in a position to measure those propositions. Therefore, they are the basic attributes of scientific method. Therefore, legal research is scientific inquiry into legal fact, and there are four attributes of scientific inquiry: logic, objectivity, propositions, and measurable. Now, when I say systematic approach basically involves a kind of application of a systematic approach to the fact which are put to inquiry. Systematic approach. Systematic approach. You have to be systematic to the legal fact which you want to put in inquiry. Again, I have used the word legal fact in very wide sense. Already I have explained. So, whatever legal fact which you want to put to inquiry, you must have a systematic approach to that inquiry. Now, what does it mean? When does that inquiry become systematic? Any case to make? When did that inquiry become systematic? Now it becomes systematic when you follow certain research methods. So you need to follow research methods from formulation of research problem to drawing inferences from the facts which are collected. So that is what systematic inquiry implies. Research method. Now, what do you mean by research method? What do you mean research method? Research method obviously refers to techniques, tools which a researcher employs for three things. First, collection of information. Now, as I said in the beginning, that research is evidence-based. Now, therefore, researcher has to be distinct from a novelist. Novelists try to create a fictitious character and use their imaginative power to build a story out of the fictitious character. But it is not possible for researcher. Researcher always has to have evidence to substantiate these inferences. So therefore, for that reason, he needs to collect the information. Which information? Information which is relevant, required for his inquiry. About the legal fact which are put to inquiry. Therefore, first thing what he needs to do is lay his hands on the facts, relevant, required to substantiate or to make inquiry into a legal fact which he has identified. And therefore, research method means here that a technique, tool used by a researcher for collection of the information. Information technically is known as data. Therefore, research method is a tool, technique researcher has to employ for collecting the relevant required information, which are technically known as data. So this is the research method. The second research method is that merely collection of information is not enough. The collection of data is not enough. What you need to do, you need to process that information. Processing, which generally we call analysis of data which are collected. So processing of data has to be done in a systematic way. And the way in which you do that processing, that way, that technique, that tool also takes the label of research method. Therefore, now research method refers to first collection and processing of data. The second one is that the way in which you establish relation between the data and unknown facts, connecting it. The way in which you connect the data with the unknown fact, that's also known as research method. And last meaning of research method is that you need to verify the connection which you want to establish between data and unknown facts. Therefore, now you need to, as a legal researcher, need to be systematic in your approach in inquiry of a legal fact, meaning thereby you need to use research methods. So therefore, research methods, in a sense, shows you the way to systematically solve the problem, have insight into the problem which you identified for inquiry. These research methods together, in fact, lay down the rules of procedure for you to make inquiry. Therefore, the use of research methods really makes your research systematic one. So now, therefore, what I'm trying to convey to you is that legal research has two essentials. One is scientific method, which insists on objectivity, logic, and second essential is use of research methods. That is the way in which you collect the information, analyze the information, and try to link it with unknown facts and draw inferences. They are the two essentials. Now, having said this one, our next question is, who can be a good researcher? What are the qualities which researcher has to have? Now, let me tell you that anybody, everybody cannot be a good legal researcher. What is that which one has to have to be a good researcher? What is that one has to have a good to become a good researcher? Any guess? Because I believe in dialogue. Any guess to make? Who can be a good researcher? Now he may be knowing his law. He has identified the fact for inquiry. He is good at collecting the information. He is good at analyzing the information. He is good at drawing relationship between known and unknown facts. But does make him the good researcher? Certainly no. Researcher has to have three qualities, three prime qualities to become a good researcher. What are they? He has to have three qualities. Now, first quality which he has to have is that he has to be objective in his approach. Objective. Now, the moment he becomes subjective, the inferences which is going to draw at the end of the day, those inferences are bound to be misleading one. They may be far away from the reality. And the moment the inferences are far away from reality, it diminishes your contribution as a researcher. Because I told you in the beginning that the sine qua non of research is that you must add something to existing knowledge. You must add something. If your research doesn't add something, then your research doesn't qualify to be good research. Therefore, the researcher has to be objective in approach. What does it mean? It simply means that when he collects the facts, he should not collect the facts which are favorable to him. He should not have preconceived notions. He should not have likes, dislikes. Maybe a subject of inquiry or maybe object of inquiry, whatever maybe. He should be like Mercury. He should be free from a subjectivity. Therefore, he has to be objective in approach. He needs to collect the facts objectively. He needs to analyze those facts objectively. He should not allow his personal disliking to mingle with the collection, analysis, or drawing inferences from the fact. Therefore, the first quality which the researcher has to have is that he must be above all personal factors, prejudices, likes, dislikes. The first quality which the researcher has to have. The second quality is that he should be value neutral. He should not have a kind of preconceived value or proposition that he holds good, that he thinks right or wrong. He should not have this kind of perception when he makes inquiry into a legal fact. He should be neutral. He should be neutral. The second quality which he or she needs to have to be a good researcher. Then third thing which he needs to have is the professional honesty and integrity. Now, whatever ideas he borrows from and tries to develop the ideas, he must acknowledge the originator. That is what academic honesty requires, academic integrity requires, and therefore you need to cite the authorities on which you are relied upon or which you want to use in your research. Otherwise, that will be plagiarized information and you will be subject to penal sanction because you are violating somebody's copyright. So therefore, you need always to convince yourself that you need to have an honesty and integrity when you undertake inquiry into a legal fact. And last but not the least, which is a consequence of research, is that you must make every possible effort within your reach to create something which is original one, which you can say this is my contribution in the field. Therefore, this is what you need to do. Therefore, these are the qualities which you need to keep on reminding yourself when you undertake an inquiry into a legal fact, that you have to be objective, value neutral, honesty, and you should strive for some original contribution or creativity in the field from which you identify a legal fact for inquiry. This is what you need to do. So therefore, now so far what I try to convey to you, that what is a legal research and who can be legal research, what is the essence of legal research. Now, assuming that you do have these qualities and you want to venture into legal research, but one thing you keep in mind, that law has multi-faces, has multi-dimensional. Law is a discipline. Unlike other disciplines, which is multidimensional. Multidimensional. Now, law is related with, take any discipline, sociology, philosophy, psychology, economics, political science, culture, history, even politics. Therefore, law as such has dimensions, has tentacles which are spread in almost all the disciplines. Now, why you need to remember this one? Because when you are trying to identify legal fact for inquiry, you must be in a position to convince yourself that the legal fact which you are going to select for inquiry may have multi dimensions, may have multi facets, and therefore this kind of multi-dimensional contextual link of legal fact indicates the orbit of a research. Orbit of a research. Now, therefore, now here legal research has kind of three perceptions. Law as such has three perceptions, and those perceptions have bearing on legal research. Are bearing on legal research. Now, what do you mean by law? Because law has, legal fact is derived from law. Legal fact which put to inquiry. As I said, legal fact may be a provision, may be a concept, may be a doctrine, may be enactment, may be an institution which you want to put to inquiry. Therefore, legal fact is a fact which is a bearing on, which is connected with law. Now, this legal fact which you want to put to inquiry, keeping in view the multidimensional facets of law, that will indicate the orbit of a legal research. Now, law can be seen as a normative science. Law can be seen as a normative science, normative prescriptive science. Now, when you look at law from this one, what are the legal facts which you can think of for inquiry? What are the legal facts which you can think for inquiry? What are the legal facts which you can think for undertaking systematic scientific inquiry? When you look at law as a normative science, as a prescriptive science, because it prescribes, it stipulates certain standards of human behavior, it lays down certain norms for human behavior. Now, when you look at law from this perception, what are the legal facts which you can think of for putting to inquiry? What are the legal facts which you can put to inquiry? When you look at law as a normative science or a prescriptive science. Any guess? I like dialogue. Now, what are the legal facts which you can think of when I say law is a normative science? Law is the norms of human behavior. What are the legal facts which you can think of for putting them to inquiry as a legal researcher? Anyone, please? Are you getting me, or just I'm just speaking to my laptop? Are you with me? Now, what I'm trying to convey to you, that suppose you have a desire to be a legal researcher, you want to undertake a legal fact for inquiry. Now, legal fact, the way in which I try to explain to you is a legal fact is a fact which is connected with law, has a bearing on law. That's a legal fact for me. And I said in that context, it may be provision, it may be doctrine, it may be concept, it may be the whole enactment, it may be institution. Now, the scope of my legal research and research methods which I need to employ depends upon the perception which I give it to law from where I want to draw a legal fact. Now, the first perception which a legal researcher may have is that law is nothing but a normative science. It is a prescriptive science because it lays down prescriptions. It lays down norms for human behavior. Now, when I have this perception to law in court, what are the legal facts which I can think of identifying and putting them to inquiry? Now, for example, I can look at, if I took this one, I say law is how it is generated. Because how it is generated, why this norm has been converted into legal norm. Why? Why? Now, why bigamy has come as a legal norm? Legal norm. So therefore, when I look at law as normative science, probably I can think of a legal fact in the sense that how is law generated? How is that legal fact generated? Generated. Who initiated that law? Who were they? Who were they who initiated this kind of norm? And who were they who opposed to it? And on what reasons? So therefore, this becomes a legal fact for me. Who were they? What were their intent? Who initiated, supported, or objected that fact to be converted into a legal fact? Now, why this norm is converted into legal norm? For what reasons? What is the contemporary effects of those legal fact? So then this is what then I say, then assuming that this legal fact has come. Now, what are the gaps in the law? Are there any gaps, ambiguities in the given law? Because sometimes drafters of the law may intentionally or unintentionally keep some loopholes in the law, some gaps in the law, some contradictions in the law. Therefore, a legal researcher can undertake an inquiry into highlighting those gaps and ambiguities. And once he has done this one, probably he may suggest some corrective measures to plug those loopholes, to bridge that gap, or he may suggest certain modifications or replacement. Now, these are the illustrative legal facts which may emerge when a legal researcher looks at law as a normative science. Please try to understand me. Now, these are the illustrative legal facts which may deserve in-depth inquiry by a legal researcher when he pursues that law is a normative science, is a prescriptive science. Therefore, these are the possible legal facts which he may put to inquiry, that who did it, who objected it, for what reasons, what gaps, ambiguities, measures, suggestion, and modification. These are some of the legal facts which you may think of inquiring into in a systematic and scientific. This is the first perception. Now, sometimes a legal researcher may not agree with the fact that law is normative science. Now, he looks at law as a behavioral science. As a behavioral science. Now, hope I'm reaching to you. Now, there may be a research scholar who does not feel that law is normative science, but he feels that reflection of behavioral patterns of the players in the domain of law. Players in the domain of law. How many players are there in the domain of law? How many players are there in the domain of law? Because he wants to look at law as institutional behavioral patterns. And therefore, he makes every effort to identify a fact from these behavioral patterns of the institutions who are players in the domain of law. According to me, there are 5 players in the domain of law. Any guess to make? There are 5 players. Any guess to make? Already I've given you a clue. There are 5 players in the domain of law. 5 players. Who are they? Who are they? Who are they? Okay, let me take you back. Now, can you see this one? Creator of law, legislature. Now, do lawmakers make law simply because they're authorized to make law? Either say yes or no. Do lawmakers make law simply if they're authorized to make law? Certainly no. Now, law is a deliberative outcome of the legislative institutions. Lawmakers make law only when, in their wisdom, think that law is the only solution to solve the problem. So therefore, lawmakers make law only when, in their wisdom, think that this solution, this problem can be solved by making a law. Now, when they try to look at this one, now sometimes you must have seen that legislators are very sensitive to certain problems, and lawmakers do turn a blind eye to certain problems. Now, to substantiate this illustration, I can say, give an example. Now, in India, growing population is a major problem, but we do not have birth control law. Now, what could be the reason? Because probably lawmakers are not that sensitive when it comes to enacting a birth control law compared to a law enacting in the area of human rights, maybe environmental protection, maybe climate change, maybe gender justice, maybe combating abuse of children, domestic violence. Now, herefore, as a legal researcher, you can try to identify legal fact as a behavioral pattern of the lawmakers, behavioral pattern. Now, similarly, sometimes judiciary may be sensitive to certain problems, but judiciary is an institution which may exhibit a patterned response to the laws enacted by the legislature. Now, you can undertake the study of judicial behavior pertinent to a legal fact. Similar is the case with the third institution, that is lawbreakers. Why do people obey law? And fifth one is lawbreakers. Therefore, there are 5 players: creator, interpreter, executor, abider, violator. Now, when I look at this law as this perception, now my legal facts category changes. For the legal facts which deserve my attention as a legal researcher, when I look at law as institutional behavioral patterns of the institutions who are placed in the domain of law. Now, can you think of any legal fact when you look at this law as this one? Now, for example, you may be curious to know why particular legislation is made. Why? Now, because here you want to see the behavioral pattern of the lawmakers, why this particular legislation is made. What is the underlying legislative intent? Why lawmakers wanted to have law to handle or to solve a social problem or economic problem? So, therefore, why particular legislation is made. Other legal fact for inquiry may be what are the forces, lobbies, pressure groups that activated that legislation, and for what reasons, what objectives. Therefore, all this may be a source of us for identifying legal fact singular or legal facts in plural, connected legal facts, to put them to inquiry when I see law as an institutional behavioral pattern. Then coming to the second player, that there may be sometimes judiciary may not be equally sensitive to legislative intent. Now, law is being made with certain purpose, and judiciary gives different meaning. Therefore, generally I say judiciary is an institution which injects life into dead letters of law. Otherwise, law is a dead letter, is a black letter. Therefore, judiciary sometimes may not tune to legislative intent. They may have different perception. Now, simple example which I can give to you, that NJA, judicial appointments, judicial accountability. Parliament enacted a legislation. The Supreme Court declared unconstitutional. Now here, therefore, you find a kind of which therefore, here the researcher may try to look into judicial response to the given legislation, to the given legal fact. And probably he may try to find out is it in tune with his intent. If not, are there any theoretical operational gaps between these two institutions? Is there any gap, misunderstanding, miscommunication? If there's a gap between what legislative intent and what judiciary interprets, now probably you may dig into the reasons why there's a gap. Is it philosophical? Is it logical? Is it legal? Is it rational? Therefore, you may try to look into the reasons which are responsible for creating this gap between legislative intent and judicial interpretation. And once you are done this one, probably you or someone else may try to suggest the means how to minimize these gaps. And here, what I'm trying to look at, I'm trying to look at the behavior of the legislature, because behavior of judiciary. Judiciary may be very sensitive to certain issues, and it may not be sensitive to certain other issues. Therefore, here I want to look at the judicial interpretation, judicial behavior when it comes to the response to given legal fact or law. Now, coming to the third player, sometimes law is sound. Judiciary has no problem with that kind of law, but executive may turn its blind eye when it comes to enforcement. They may be dormant. They may not take that law very seriously when it comes to implementation or execution. The well-known examples could be anti-intouchability law, dowry laws. Now, executives are not equally sensitive to enforcing the laws, and therefore here you can identify a fact, the way in which executive implements law. Now, therefore, when you look at this one, probably you need to find a legal fact. Why particular legal fact or law has become merely symbolic one, merely cosmetic legislation, because it remains in a statute book, it is not executed with the same zeal with which legislature has enacted. Therefore, why particular law has become dysfunctional or unoperational or less operational. Now, this becomes a legal fact for you to undertake systematic scientific inquiry. Then probably other legal researcher or you may try to find out what are the factors we are responsible for. What are the situations which are responsible for this kind of scenario, that there's a gap between law and its implementation. Therefore, and then probably you may suggest strategies to overcome these factors. Now, therefore, fourth legal fact which you why do certain people oppose that law? Why do certain people oppose it? Now, another example is untouchability law. Now, some people do oppose it because caste system is in their blood. Caste system has become the part of their personality. Therefore, it is difficult for them, or maybe it will take longer time for them to assimilate this kind of legal expectations in their behavior. So therefore, here some people may abide by it, and some people may deviate from it. And therefore, you as a legal researcher can identify the legal fact to know the reasons why particular law has been accepted or not accepted by the community. Now, the third perception of a law could be that there may be research scholars who refuse to look at law as normative science, or there may be some scholars who refuse to look at law as a system of behavioral patterns of the institutions, but he or she may have perception that law can be seen as an agent of change, believing Lascaux Pond that law is social engineering, social engineering, and therefore he tries to look at law as an instrument of change, Now, when he has this perception, what are the legal facts which you can think of for inquiry? Then he gets to make what legal facts which you can think of that can be put to systematic scientific inquiry. Now here, This perception generally involves impact studies. What has been the effect or impact of a given legal fact or a law in the given social setup? Therefore, here the researcher tries to see the impact, effect. Now, to put in general terms, one can say the researcher tries to see social face of law, social reaction of law, law in action, not the law in a statute. Therefore, this becomes a legal fact for him or her, that what has been the impact of given law or legal fact. Now, then the second legal fact could be, has society accepted it? Has it become a part of social behavior? If yes or no, what reasons? Why this legal fact is not being assimilated, accepted, partly accepted by the society, by the society. Now, then probably he may try to find out what is the gap between the legal ideals and the actual practice. Why? There's a gap between these two, and probably he may try to find out those gaps in research, because he sees that what lawmakers intend to achieve, that has not been achieved by the society. Therefore, he or she tries to highlight the factors, identify them with evidence that which are responsible for creating this gap between legal ideals and social facts. Another legal fact could be that whatever institutions are being created by the lawmakers, now are they serving the social needs, or have they become outdated? Have they become outdated? For example, CVC was created initially. Now has some institutions being overused by the executive? For example, CBI, for example, ED. Now, are they really serving the purpose for which they are created, or are they serving the needs of the political masters? Political masters. Now, therefore, here you can look into the kind of utility of these legal institutions vis-a-vis their role, which was initially given to them and which they are performing right now, and therefore you can see whether they have social values or not. Now, therefore, now the point which I'm trying to convey to you is that the legal facts which you identify, can put to inquiry, may vary from one perception to other perception. So therefore, there cannot be a kind of set legal facts. It depends upon the perception of a researcher of the law in court. Law in court. The moment he or she looks law as a normative science, have given illustrations of the legal facts which may worth inquiring by the legal researcher. Some other legal researcher may look at law as a system of behavior. There are those five players. Here I have given an illustrative list of the legal facts which deserve kind of probing by the legal scholars. And third perception of legal researcher could be law as an agent of change or catalyst for bringing a social economic transformation. Therefore, here there are certain legal facts which may put to inquiry. Now, therefore, here this is what the kind of panorama of the nature of the scope of the legal research, which has closely connection with the perception which legal researcher has. Now, therefore, now what is the essence of these perceptions? Now, essence of this kind of legal research has different one. So the moment when I look at law as normative science, what essence is an analysis of the black letters of law. Analysis. When I look at law as a behavioral pattern, now I need to have social orientation to the behavior of these institutions. Now here, the essence of legal research is different. When I look at law as an instrument of change, my focus of attention would be assessing the impact of the legal pattern law. Now, therefore, the point which I'm trying to convey to you is that the essence of legal research is closely connected with the perception which you have about the law in court, and accordingly, you need to be careful about the legal fact which you want to put to inquiry, and the research methods which you need to employ. Research methods also do vary from one perception other perception. Now, assuming that you have this research methods mastery over that one, you have a skill to identify legal facts, whatever the perception which you have about the law. Now, the next question is why to undertake legal research? Why? What is the essence of or utility of legal research? Now, legal research may be carried out for variety of purposes, but I'll just mention a few. Not significant, not in order of priority, but generally legal research is carried out for the following purpose. First is to ascertain law on the given topic, ascertainment of law. Now, as I said in the beginning, the ascertainment of a legal fact is not an easy task. It's not an easy task because law is scattered. We traverse in a jungle of laws. Therefore, ascertaining law on a legal fact sometimes may be difficult one. Suppose you do that one, probably that is going to be your contribution. Therefore, legal research can be undertaken to ascertain law. The other reason which legal research can be undertaken and thereby to contribute to the development of science of law is to highlight the gaps and ambiguities in a statutory law. Sometimes, as I said, the drafters of the legislation may intentionally or unintentionally keep some gaps, some loopholes, some contradictions. So legal researcher with evidence can highlight those gaps and ambiguities, and therefore he can put those gaps and ambiguities and those legal facts to critical examination. Critical examination to convey, to draw inference whether that law is consistent, coherent, or stable one. The fourth purpose of legal research could be to take a social audit of law, because law operates in a complex social setting. And therefore you need to take an audit of law prior its enactment and post its enactment. Prior, who were behind it, who initiated it, what objectives. Post enactment is impact analysis. Therefore, here legal researcher may try to take social audit of law. Then other purpose of legal research could be to investigate gap between what law intends to achieve and what law has achieved. So gap between legal ideals and actual practice could be a purpose for undertaking systematic scientific inquiry of a legal fact, or maybe to understand effectiveness of a given law. Has it really been effective to combat, to handle social problem or economic problem. And therefore, once it does that, probably he or she may try to bring certain changes. Now, it's about why. Now, last theme which I want to address is that how are you going to undertake legal research? Generally, I say there are 7 major steps which legal researcher has to follow in systematic scientific inquiry into a legal fact. Generally, I say Saptapadi of legal research. The first one is identification, formulation of research problem. And do remember that I said that you have to be objective from formulating research problem to the conclusion. But identification, formulation of research problem is a very difficult task. It's very easy to say in the classrooms, but it's a very difficult task that how are you going to identify a legal fact for inquiry? First, you need to identify an area of your interest. And from there, you need to narrow it down, and then you have to settle with a micro problem, because research generally is vertical one. And once you identify this micro problem, probably you need to convert that micro problem into a proposition. And that proposition is a statement of research problem. But when you're dealing with a kind of variables, social and legal one, you need to have a hypothesis. Hypothesis is tentative testable statement between 2 or more than 2 variables, invariably a legal variable and non-legal variable. Therefore, this is the first step which you need to follow, and this is the stage where researcher begins. Generally, we say research does not begin the moment the researcher becomes curious. No, but when he tries to kill his curiosity by Formatting is a problem, that is starting point of research, and therefore the first step of research is formulation of a research problem, which is not an easy task. The second one is that undertaking a serious review of literature, published literature on the topic. Why? Why a legal researcher is expected to undertake literature review? For two, three reasons. One is to understand the legal framework which has been used by the early researchers. Legal framework. Now, why is that legal framework sound? Legal pattern sound. If it's sound, now you can think of, can you borrow that legal framework for a proposed inquiry? Borrowing legal framework doesn't violate copyright. Copyright. So therefore, to identify the legal framework used by the researchers and its utility and possibility of using it for your research. The second reason why you need to undertake serious literature review is that to find out what has been the methods which have been used by the early researchers collecting information, collecting data, and what way they analyze the data. Therefore, again, you can learn from their experience. The second reason why your supervisor really asks you to undertake literature review. And third one is mapping the proposed research. You need to map. Now, as to whether the problem which identified is a grave problem, does it have potentials to contribute in the existing field? So therefore, it helps you to convince yourself that your research topic is going to significantly add to the existing literature, existing knowledge. The third step is that once you are done this one, generally you need to prepare a blueprint of a proposed research. This blueprint is nothing but a mental visualization of all the possible steps or the chapters which you want to put, which are themes which you want to probe in. This is what research design. Fourth one is, of course, collection of information which is relevant, required, but merely collection is not going to complete the research. You need to analyze it. Therefore, fifth stage, analysis of data, and data never speak for itself. You need to give meaning to the data, and therefore interpretation of data is last but one step. And research can never be private, is a public one. Therefore, you need to communicate your findings to your audience, and thereby giving them an opportunity to judge your contribution in the existing field, that is report writing. So all the 7 steps have to be followed in a systematic and scientific way. And therefore, this is what the essence of or essentials of legal research. Now here I end my presentation. Thank you.